Kenya PLC versus Cabinet Secretary for Ministry of Health, commonly referred to as the BAT case, the Supreme Court delimited the following binding framework for public participation. Principles are that, as a constitutional principle under Article 10(2) of the Constitution, public participation applies to all aspects of governance, that the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation, that the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation, and the onus is on the public entity to give effect to this constitutional principle using reasonable means. That public participation must be real and not illusory. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. That public participation is not an abstract notion, it must be purposeful and meaningful. That public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. That public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. The fact that someone was not heard is not enough to annul the process. That allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the peculiar circumstance of each case, including the mode, the degree, the scope, the extent of public participation is to be determined on a case-to-case basis. Additionally, in Cabinet Secretary for National Treasury and Planning and 4 others versus Okiya Mtata, the Supreme Court held that the constitutional threshold for public participation is one of reasonableness, that the process must afford the public a genuine and meaningful opportunity to be heard, and that Parliament must take reasonable measures to ensure the proposal, views, and suggestions received. The court spoke as follows. In the BAT case, this court established the standard that duty bearers must meet and the threshold courts should use to determine whether duty bearers have fulfilled their obligations with respect to public participation. This threshold is set at a reasonableness standard. In its guiding principles on public participation, this court defined this threshold as follows: that public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. Close of quote. This and the broader corpus of jurisprudence firmly established that when the Constitution the Constitution demands is not necessarily the most intensive form of participation in every case, but always a form that is meaningful, purposeful, and proportionate to the nature and gravity of the decision being made. This principle finds its clearest expression in the decision of the Constitutional Court of South Africa in Doctors for Life International versus the Speaker of National Assembly and others, where the court held that the degree and nature of participation must be calibrated to the subject matter and the potential impact of the decision on affected persons. The proposition has been consistently adopted by our courts in Mui Coal Basin Local Community and 15 others versus the Permanent Secretary, Ministry of Energy. The Court of Appeal affirmed that decisions of greater consequence demand more robust and substantive engagement, and that public participation ought to be meaningful rather than a tick box exercise. The High Court reinforced this position in Robert Gakuru versus Governor Kiambu County and Institute for Social Accountability versus the National Assembly, where it held that the standard of participation required is directly informed by the gravity and reach of the decision in question. We believe that it is within this rich conceptual context that the courts must approach questions about the adequacy of public participation in any given case, whether arising from the legislative process or from any other exercise of public power in which the Constitution demands the people's involvement. The focus ought to be on whether the participation that occurred was real, substantive, and meaningful. As we now turn to apply these principles to the specific facts of this matter, we do so bearing in mind that the constitutional standard is not one of perfection, but equally, it is not one of mere tokenism. The standard is meaningful participation, and that standard must be assessed with rigor, sensitivity to context, and fidelity to the constitutional vision of a government that is truly of, by, and for the people. Certainly, the impeachment of a deputy president is not an ordinary legislative act. It is amongst the most consequential, solemn, and irreversible decisions that any parliament can make. It involves the removal from office of a person who holds the second highest constitutional office in the republic, and an office to which the holder was elected by the sovereign will of the people through a general election. The gravity of that decision cannot be overstated. It affects not only the individual whose tenure is at stake, but the constitutional architecture of the executive, the stability of government, and the democratic expectations of millions of citizens who cast their vote in the 2022 general election. It is precisely because of this gravity that the public participation required in connection with an impeachment process must be held to a standard that is both qualitatively and quantitatively meaningful. It is equally against this exacting standard that we assess the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua. On the question of notice, the National Assembly adduced evidence that notices of the public participation exercise were published in multiple newspapers of wide national circulation, including the Daily Nation, the Standard, the Star, and Taifa Leo on the 2nd, the 3rd, the 4th, and the 5th of October 2024. We recognize that the publication of the notices in both English and Kiswahili was a deliberate effort to reach citizens across the linguistic divide and to ensure that the exercise was not confined to the English-speaking, urban, and formally educated segment of the population. Notice was additionally published in the Parliament's official website and on social media platform, therefore extending the reach of the process to citizens who access information through digital means. The option of submitting their views by email, by post, hand delivery, and online submissions could be made through Parliament's website, which further meant that participation was not contingent on physical presence or geographic proximity to a hearing venue. On the question of numbers, the evidence shows that just over 223,000 members of the public participated in the exercise. We are mindful that the significance of a participation number cannot be assessed in a vacuum. It must be considered in the context of the time available, the channels provided, the nature of the decision being made, and the standards previously endorsed by the courts. The Supreme Court in the BAT case affirmed that both quantitative and qualitative components are relevant to such an assessment. Equally, in Robert Gakuru, the Court of Appeal affirmed the principle that the quantitative component of public participation is a relevant but not determinative consideration, and that the adequacy of participation must be assessed in light of all the circumstances. Viewed against these standards, a participation figure of 223 citizens achieved within the constrained timeline represents a considerable level of civic engagement in a single parliamentary process. We say so further considering the relationship between the state's obligation to facilitate public participation and the public's exercise of the right to participate. These are two distinct constitutional responsibilities, and the law does not conflate them. The constitutional obligation that falls upon Parliament and upon all state organs charged with facilitating public participation is an obligation of facilitation, not an obligation of outcome. Parliament is constitutionally required to provide adequate notice, accessible channels, sufficient information, and a genuine opportunity for the public to engage. That obligation, once discharged, exhausts the constitutional duty of the facilitating organ. At least that is our understanding of the Supreme Court's pronouncement in Cabinet Secretary for National Treasury and Planning that, I quote, based on the textual markers herein, Parliament's duty is to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. As is plain from its wording, this provision only imposes a duty to facilitate public participation and involvement in the legislative process, end of quote. We hold the view that what the public chooses to do with the opportunity is a matter of individual and collective civic agency, and that agency belongs to the people and not to Parliament. To hold Parliament responsible for the volume of public participation and to judge the constitutional adequacy of a public participation exercise by the number of citizens who choose to avail themselves of it would be to conflate the duty to provide an opportunity with the duty to compel its uptake. We take the position that a process that was accessible to all but availed by a few is not, by reason of low turnout alone, constitutionally deficient, provided that the low turnout was not the product of inadequate notice, inaccessible venues, suppression of participation, or any other failure on the facilitating organ. This principle finds support in comparative jurisprudence. The Constitutional Court of South Africa in Doctors for Life International case was emphatic that Parliament bears a duty to facilitate public participation and that the standard against which that duty is measured is one of reasonable facilitation. It therefore follows that the adequacy of the exercise ought not to be measured by the number of members of the public who ultimately chose to engage or by whether any particular outcome was achieved. The true measure is whether the state discharged its obligation to create conditions in which meaningful participation was genuinely possible. We are therefore persuaded that the appropriate legal standard against which compliance by the National Assembly must be measured is not one of perfection, but one of reasonable sufficiency in the circumstances. As we have stated, the Constitution does not demand flawless execution of public participation. What it demands is a genuine, accessible, and meaningful opportunity for the public to be heard. Even accepting, as we do, that logistical and operational challenges may have arisen in certain isolated cases, which is not an uncommon occurrence in any large-scale nationally coordinated exercise conducted under time pressure, such localized deficiencies would not invalidate the entire process, as guided by the Supreme Court in the BAT decision. The evidence before this court shows that the door was opened widely, accessibly, and in good faith. Additionally, the fact that His Excellency Gachagua's response to the charges was not availed to the public during the window does not, without more, render the exercise deficient. The purpose of public participation in the impeachment process is substantively and functionally distinct from the adversarial hearing to which the respondent is entitled. The public was called upon to express its views on whether the allegations assessed on their face were of sufficient gravity to warrant a removal of a constitutional office holder. It was not and was never intended to be a mini trial of the charges. The Constitution vests the final decision-making authority in the National Assembly and the Senate, both of which are representative bodies exercising a delegated mandate from the people. These institutions heard, considered, and weighed both the allegations and His Excellency Gachagua's full response before proceeding to vote. On the question of compliance with the court orders of 3rd October 2024, which directed the National Assembly to organize public participation at least at constituency level, we find upon careful evaluation of the evidence placed before us that the National Assembly took demonstrable and timely steps to give effect to those directions. A memo from the Clerk of the National Assembly contained at page 996 of the National Assembly's documents provided as follows. The title of the memo was Collection of Public Views on the Special Motion for Removal from Office by Impeachment of the Deputy President of the Republic of Kenya. And the Clerk of the National Assembly writes, as you are aware, the National Assembly is currently considering a special motion for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. To facilitate this process, public hearings were scheduled to be held in all 290 constituencies on Friday, October the 4th, 2024 from 8 to 5 p.m. and members of the public were notified to submit their views to the constituency or county. Offices of all members of Parliament of the National Assembly notified to submit their views to the constituency or county offices of all members of Parliament of the National Assembly. By a court order issued on the 3rd of October 2024, the High Court in Kenya sitting at Kerugoya directed that the National Assembly organize similar public hearings closer to the citizens, at least at constituency level, on each constituency in Kenya to enable the constituents of members of Parliament responsible for the impeachment process nationally to engage with and participate on hearings and or any other suitable modes by which citizens at that level can participate and offer their representations. In this regard, you are required to continue facilitating and coordinating the public participation exercise on the special motion within your constituency or county office. Please ensure that you implement the following: availability of forms. Ensure that copies of the public views template are physically available in your offices. In addition to the physical forms availed earlier, additional forms can be downloaded from the Parliament's website. 2. Collection of views. Collate all views, including memoranda, completed public views template, and any other submissions relating to the exercise. Note to transcribe oral submissions into written form using the designated template. 3, submission of collected views. You are required to submit the collated views arranged per constituency to the collection center, which has been set up in Parliament Building, Nairobi, at the entrance of Bunge Tower. Alternatively, you may hand over the forms to the respective officers designated for your counties or constituencies as per the attached list. All submissions must be received by Sunday, the 6th of October, 2024. Please ensure that your respective offices remain open on Saturday, the 5th of October, 2024, as from 8 a.m. to 5 p.m. to facilitate the exercise. Please utilize the operation facilities and resources available in your offices to print or photocopy the forms and to support any other aspects of this exercise. For seamless coordination, we have shared the contacts of parliamentary officers responsible for each county or constituency. I close the quote. The petitioners allege that no actual hearings were held at the constituency level, contending in effect that the exercise was a procedural facade. The allegation was effectively countered by substantial evidence presented by the National Assembly. This included the report of public participation on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. The report contained a detailed analysis of the aggregated constituency tallies. See table number 4 at page 180 of the report, supported by photographic documentation of the exercise conducted across multiple constituencies, as well as an official account comprehensively outlining the scope and substance of the proceedings. It is a well-settled evidentiary principle that a bare denial or unsubstantiated allegation cannot displace positive and particularized evidence to the contrary. The petitioners bore the burden of proving on a balance of probabilities that the public participation was an illusory or ineffective exercise. That burden was not discharged. It was also common ground that the public participation was tabled before the National Assembly on the 8th of October 2024. Members of Parliament had the opportunity to consider it before and during the debate. One of the petitioners mounted a specific and pointed challenge to the integrity of the report's data, contending that the figures recorded for Keio South were statistically impossible in that they purportedly reflected a support rate of 162.78%, a figure that, if accurate, would self-evidently exceed the mathematical ceiling of 100% and thus portray either gross error or deliberate manipulation. We have subjected the report to careful scrutiny. Our analysis shows that in Keio South, of the 820 responses recorded, 807 supported the impeachment, 12 opposed it, and 1 selected other. This translates to 98.41% in favor, 1.46% against, and 0.12% categorized as other. These figures, in our view, are mathematically sound and fall within the permissible range of 0 to 100% and disclose no statistical anomaly of the kind alleged. The petitioner's contention, presented as a statement of fact, is therefore not borne out by the document itself. We further find that even if isolated errors were present in data entry, tabulation, or transcription, if those errors were demonstrated to exist within a report of this scale, such minimal errors would not without more vitiate to the entirety the otherwise lawful and substantially compliant public participation exercise. Therefore, having wholly examined the totality of the evidence produced before us, and having applied the constitutional and jurisprudential standards authoritatively laid down on the nature and quality of public participation required, we are satisfied and hereby find that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua as Deputy President met the requisite constitutional threshold in all material respects. With regards to the Senate not conducting its own public participation, the petitioners contended that the Senate acted in violation of Article 118 of the Constitution by failing to conduct its own independent public participation exercise prior to deliberating on the impeachment of His Excellency Gachagua. This argument, while not without surface appeal, cannot be sustained upon a careful and purposeful reading of the constitutional architecture governing impeachment proceedings, and we reject it for the following reasons. The starting point is a principle of constitutional specificity. Where the Constitution makes express and particular provision for a specific process, that specific provision governs, and general provisions must yield to it to the extent of any inconsistency or tension. Article 145 of the Constitution prescribes with particularity the role and function of each House of Parliament in the impeachment process. Under that provision, the Senate's designated function is to hear the charges preferred against the Deputy President, to receive and evaluate evidence in respect of those charges, and to decide on whether the Deputy President should cease to hold office. This is, by its very nature, an adjudicative function, and one that is quasi-judicial in character, akin to the conduct of a tribunal. It is not a legislative or policy-making function. The Senate, at this stage of the process, sits not as a law-making body, but as a constitutional adjudicator, and the procedural obligations that attend to that role are correspondingly different. Article 118, by contrast, imposes obligations on Parliament in the conduct of its legislative and other business. It provides in material part that Parliament shall conduct its business in an open manner, that its sittings and those of its committees shall be open to the public, and that Parliament shall facilitate public participation and involvement in its legislative and other business. The operative phrase is legislative and other business, and the interpretive question is whether Senate's adjudicative role in impeachment proceedings falls within the scope of that phrase. We find that it does not. The phrase other business must, on a proper application of the Eusdom Generis canon of construction, be read as business of a similar nature to legislative business. That is, business involving the formulation, review, or consideration of policy or law. We respectively associate ourselves with and adopt as correct the position taken by this court in Mwangaza versus County Assembly of Meru, that public participation in impeachment proceedings primarily occurs at the county assembly level rather than at the Senate level, since the county assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for final determination. End of the quote. At the Senate stage, the function being discharged, as we have said, is adjudicative rather than consultative. We find that the constitutional principle underlying that holding is not confined to the impeachment of governors. It is a principle of general application that derives its force from the structural logic of the impeachment framework embedded in the Constitution, and it applies with equal force and validity to the impeachment of the Deputy President under Article 145. A second invocation of the same procedure in respect of the same charges, the same allegations, and the same subject matter at the Senate level serves no additional constitutional purpose. We therefore find that the Senate did not violate Article 10 or 118 by failing to conduct its own independent public participation. Finally, the question of whether public participation was constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President calls for a holistic interpretation of Article 149(1) of the Constitution, read in its proper textual, structural, and purposive context. Article 149(1) provides in express and unambiguous terms that within 14 days after a vacancy in the office of Deputy President, the President shall nominate a person to fill that vacancy, and that the National Assembly shall vote on the nomination within 60 days of receiving it. The correct approach to that interpretive exercise is well settled. The Supreme Court affirmed in the matter of the principle of gender representation in the National Assembly and Senate that constitutional interpretation must be holistic and that no provision of the Constitution may be read in isolation, divorced from the broader architecture of the document of which it forms part. The court elaborated the context of that holistic approach in the matter of Kenya National Commission on Human Rights, holding that holistic interpretation requires contextual analysis, which is reading a constitutional provision alongside and against related provisions so as to arrive at a rational and principled understanding of what the Constitution must be taken to mean, having regard to its history, the issues in dispute, and prevailing circumstances. It is this disciplined, context-sensitive methodology that we apply to the question at hand. A holistic reading of Article 149(1) in its contextual context reveals compellingly that this provision is self-executing. It prescribes a complete and self-contained procedure of nomination by the President within 14 days, followed by a vote by the National Assembly within 60 days. It makes no cross-reference to any other article for supplementary procedure. Critically, it makes no mention of public participation, nor of committee vetting, nor of any other consultative mechanism. The framers of the Constitution were not silent on public participation by inadvertence. When they intended to require it, they said so in express terms. Article 118(1)(b) expressly mandates Parliament to facilitate public participation in its legislative and other business. The deliberate omission of any equivalent requirement from Article 149(1) is itself a constitutional signal that must be given interpretive effect. To read a public participation requirement into Article 149(1) where none appears in the text would be to engage in precisely the kind of unbridled extrapolation that the Supreme Court cautioned against in Kenya National Commission on Human Rights. The constitutional text of 149(1) is further instructive in its precise choice of language. The provision directs that the National Assembly shall, and in quotes, vote on the nomination. This is a deliberate linguistic choice by the constitutional drafters, and it is not open to a court to substitute its own preferred terminology for that which the Constitution has expressly employed. As the Speaker of the National Assembly correctly ruled, the phrase vote on connotes an electoral determination so that the National Assembly was in constitutional substance electing the Deputy President from among the nominee presented by the President and not approving an executive appointee in the manner of a parliamentary vetting process. That interpretation is faithful to the constitutional text and is consistent with the structural design of that provision. This understanding is further reinforced by Articles 1, 2, and 1, 3 of the Constitution, which vest sovereign power in the people and provide for its delegation to, among other organs, Parliament. When the National Assembly votes on a nominee for Deputy President under Article 149(1), it is not acting as a conduit for public opinion, but exercising delegated sovereign authority on behalf of the people. The Constitution makes a deliberate structural choice not to provide for a by-election to fill a mid-term vacancy in the office of the Deputy President, electing instead to vest that determination in the National Assembly as the people's primary representative institution. That choice reflects a conscious constitutional calibration of the respective roles of participatory and representative democracy, a calibration that this court is bound to respect. To accept the petitioner's contention that public participation is a constitutional prerequisite for every decision of constitutional importance would be to obliterate the distinction between participatory and representative democracy and to impose an obligation on the National Assembly to conduct public participation before every significant vote, including the election of the Speaker, the Deputy Speaker, and appointment of committee chairs. That is plainly not what the Constitution requires. As this court confirmed in Okoiti and 6 others versus Cabinet Secretary for National Treasury and Planning, where it was held that the representative democracy as a complement to participatory democracy is independently and fully constitutionally recognized. The Supreme Court stated as follows, that Article 1(1) declares that the sovereign power belongs to the people of Kenya and that power can be exercised only in accordance with the Constitution. Article 1(2) further proclaims that the people may exercise their sovereign power either directly or indirectly through their democratically elected representatives. It is this direct democracy aspect the Constitution provides for citizens to participate in referenda on certain constitutional amendments as outlined in Article 255. Additionally, it promotes a participatory approach to governance with Article 10(2)(a) identifying democracy and participation of the people as national values and principles of governance. This is reinforced by specific constitutional obligations such as the duty imposed on Parliament under Article 118 1B to facilitate public participation and involvement in its legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1(3) states that sovereign power is delegated to specified organs, state organs, including Parliament and the legislative assemblies of county governments. Moreover, Article 94(1) of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149(1) is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even were one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercised their votes. We are therefore satisfied that this openness and transparency, which is a constitutional core of Article 118(1)A's requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149(1). Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce itself on the National Assembly's Standing Orders number 64-2 and 65, as well as Senate Standing Orders 75, 78, 79, and 80. Beginning with the National Assembly, some of the petitioners assailed the constitutionality of Standing Order number 64-2, contending that the provision imposed an impermissibly truncated 7-day timeline for the disposal of impeachment proceedings. They argued that such compressed timelines undermined meaningful public participation and curtailed the rights to a fair hearing guaranteed under the Constitution. They thus prayed for a declaration that Standing Order 64-2 is unconstitutional, null and void to the extent that it prescribes a timeline that is incompatible with constitutional requirements for public participation, fair hearing, and compliance with court orders, and an order of certiorari to quash Standing Order number 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. The respondents in answer defended the constitutional validity of Standing Order 2 and 5, which requires a special committee to report within 10 days, and submitted that it would be illogical to impugn a standing order that prescribes a 7 to 12-day time frame when the Constitution itself operates within a similarly compressed time frame. The respondents further submitted that Article 124(1) expressly empowered each House of Parliament to make standing orders for the orderly conduct of its proceedings, and that Standing Order 64(2) is a legitimate and necessary operationalization of that constitutional framework. They urge the court to exercise restraint in accordance with the separation of powers on the issue. Having carefully considered the rival contentions of all the parties, we now pronounce ourselves as follows. It is trite that standing orders are subordinate legislation deriving their authority not from Parliament itself, but from the Constitution. Article 124(1) of the Constitution expressly empowers each House of Parliament to make standing orders for the orderly conduct of its proceedings, including those of its committees. Article 124(2) further entrenches the role of parliamentary committees within this framework. Being creatures of the Constitution, we agree with the submission that standing orders must at all times conform to the spirit of the Constitution, its values and animating principles. They cannot rise above the instrument that gives them life. Standing Order 64 prescribes a procedure for removal of the Deputy President under Article 145 of the Constitution. Standing Order 65(2) extends this procedure with necessary modifications to the impeachment of a Deputy President under Article 151(b) of the Constitution. Standing Order 64(1) requires that a member seeking to initiate such a motion must submit it in writing to the clerk, clearly stating the grounds of removal supported by at least 1/3 of all members. The motion must particularize the alleged gross violation of the Constitution or other written law, cite the precise provisions alleged to have been violated, and be accompanied by evidence sufficient to substantiate the allegations. The specifically impugned provision, Standing Order 64(2), by the Speaker within 3 days in accordance with Standing Order 47, and thereafter by the Assembly within 7 days of notice. Should the Assembly fail to act within that period, the motion is deemed withdrawn and may not be revived in the same session save with the leave of the Speaker. The combined effect is that once an impeachment motion is properly filed, it is subject to strict and unforgiving timelines. 3 days for the Speaker's action and 7 days for the Assembly's disposal, failing which the motion lapses in its entirety. It is these rigid timeframes that the petitioners impugned as unconstitutional. Now, the constitutional provisions engaged by the challenge are uncontested. Article 2(4) of the Constitution, which provides in terms that admit of no ambiguity that any law, including subordinate legislation that is inconsistent with the legislation with the Constitution, is void to the extent of the inconsistency, and any act or omission in contravention of the Constitution is invalid. Article 50, which guarantees the right to a fair hearing, and Article 10 and 118, which further enshrine public participation as a constitutional obligation binding on all state organs, including Parliament, in the exercise of their functions. We have examined at length the constitutional requirements and parameters that govern public participation in impeachment proceedings, and we have set out the applicable principles in detail in the preceding sections of this judgment. In determining whether the timelines in the impugned standing orders contravene these constitutional imperatives, it is not lost on us that Parliament is not a resource-constrained institution. It possesses the institutional capacity, the administrative infrastructure, and the constitutional mandate to reach every part of the Republic through its structures at both the county and national levels. If Parliament genuinely considered 7 days to be a sufficient window for public participation, it bore a corresponding constitutional obligation to deploy its resources adequately. to ensure that the process was not merely open in form, but accessible in fact, and that it met the participation threshold authoritatively settled in the BAT decision. A compressed timeline, standing alone, is therefore not necessarily a constitutional infirmity. A compressed timeline, accompanied by an under-resourced and inadequately facilitated process, is an altogether different matter. Still, the question that this court is required to answer is whether 7 days encompassing the logistical demands of public notification, the organization of participatory forums across a diverse and geographically expansive republic, the receipt and meaningful consideration of public input, and the Assembly's own deliberation on a matter of this constitutional gravity is structurally adequate to meet that threshold. We draw from the Supreme Court of Canada's holding in Hyde Nation versus British Columbia, Minister of Forests, a 2004 decision, that the adequacy of any participatory process must be measured against the gravity, as we have said, of the decision that is being made, and that the more consequential decision, the more robust the participation exercise must correspondingly be. At the same time, we are mindful of the importance of according appropriate deference to Parliament in the regulation of its internal proceedings as required under Article 124(1) of the Constitution. In the Supreme Court decision in the Speaker of National Assembly versus Attorney General, the Supreme Court stated that the court would be averse to questioning parliamentary procedures formulated to regulate internal workings, and the court would not do so as long as the same do not breach the Constitution. Having regard to all the foregoing, we do not consider it warranted to declare Standing Order 64-2 unconstitutional. A declaration of unconstitutionality is a remedy of last resort and a judicial act of the gravest constitutional consequence, not to be visited against upon rather a legislative provision where the provision is capable of a constitutional interpretation or application. We are further guided by the principle of constitutional avoidance that where a provision of subordinate legislation can be read and where it can be applied in conformity with the Constitution, the court ought not to strike it down when a less drastic remedy is available. This principle was affirmed by this court in IEBC versus Maina Keai and 5 others, where it was held that interpretive generosity must extend where reason permits to the provisions whose constitutionality is challenged. We are not persuaded that the mere existence of a 7-day timeline taken in isolation and on its face renders Standing Order 64-2 void. A provision is not unconstitutional simply because it is capable of being applied unconstitutionally. The vice lies not in the number of days prescribed, but in what Parliament does or fails to do within those days. The timeline, considered as an abstract legislative proposition, is therefore not in itself the source of any constitutional infirmity. The infirmity, where it arises, lies in the manner of implementation, and in whatever Parliament operating within that compressed window deploys, Parliament operating within that compressed window deploys adequate resources, establishes genuinely accessible structures, and puts in place meaningful mechanisms sufficient to discharge its constitutional obligations of public participation under Articles 10, 50 and 118 in substance and not merely in form. The distinction we draw is between a provision that is unconstitutional on its face and void in all its applications, regardless of how it is applied, and one that is conditionally constitutional, as in valid in law, but only where its application is accompanied by the institutional effort and constitutional seriousness that the gravity of impeachment proceedings demands. Standing Order 64-2 falls, in our judgment, in the latter category. In declining to strike down Standing Order 64-2, we instead note that the timeline prescribed in that standing order is not constitutionally mandated. Unlike certain procedural requirements that derive their specific content from express constitutional text, the 7-day window is a creature of parliamentary regulation alone. Parliament was free to prescribe a longer period and still remains free to do so. The experience of the first impeachment of a deputy president to come before the National Assembly under the Constitution of Kenya 2010 might have been a sobering constitutional experience. It may have exposed in real time the structural tensions that compressed timelines have the potential to create when applied to proceedings of national consequence. We commend to Parliament for its serious consideration in the exercise of its sovereign authority to regulate its own proceedings, the question of whether the timelines prescribed in Standing Order 64-2 remain adequate in light of this experience, and whether a timeline that builds in more time for public participation and for the Assembly to deliberate with the gravity that removal from constitutional office demands would not be more befitting of the constitutional moment that the impeachment invariably represents. As it stands, however, we find nothing unconstitutional about the standing order. With respect to the Senate standing orders, the petitioners assailed the constitutionality of Standing Order 75, 78, 79, and 80 to the extent that they apply to the Deputy President, advancing their challenge on 3 grounds. First, that Standing Order 79 was a mechanical imputation of the presidential impeachment framework to the Deputy President's distinct constitutional position without any effort to identify the required modifications as required by Article 150 to 152. Second, that the appointment of a special committee was mandatory under Article 145(3)(b), and that Standing Order 79 did not mirror this requirement. Third, that the 14-day timeline under Standing Order 75 was structurally incompatible with Articles 47, 50, and 145(5), and was grossly inadequate for proceedings involving 11 complex constitutional allegations. The respondents maintain that Article 145(3)(b) uses the word may, which confers a discretion and not a mandatory obligation, that the fact that Standing Order 80 expressly provided for a plenary alternative, while Standing Order 79 did not, was constitutionally significant, as the discretion was conferred by the Constitution itself. They further submitted that Article 152 did not require a formal or recorded exercise of identifying modifications, and that the modifications were implicit in the different constitutional status of the Deputy President. They relied on Speaker of the Senate and another versus Attorney General and another for the proposition that courts should not read into the Constitution obligations that its framers deliberately chose not to include. We have considered the submissions put forward by the parties, and for the avoidance of doubt, standing orders, we provide verbatim what the Standing Order 75, 78, 79, and 80 all provide. Allow me not to go through that. The principle that standing orders must conform to the Constitution applies with equal force to the Senate as it does to the National Assembly for the reasons we have already set out in the preceding section of this judgment. Our jurisdiction to examine that conformity is equally settled and will rely on the case of Orange Democratic Party versus Speaker of National Assembly and Ombogi and 9 others versus County Assembly of Nyamira. We note that Standing Order 78 largely mirrors the impeachment procedure provided for under Article 145. As such, the question of whether the special committee contemplated under standing orders is mandatory or discretionary and the constitutionality of those standing orders is in the context of Article 145(3)(b is addressed separately in the next ground. On the specific challenge to the absence of a formal recorded modification process under Article 150 sub-article 2, some petitioners argue that the phrase with necessary modification in Article 150 sub-article 2 of the Constitution is a mandatory constitutional directive requiring Parliament to enact a substantive legislative framework tailored to the distinct office of the Deputy President. They emphasize that unlike the President, the Deputy President enjoys no civil or criminal immunity under Article 143, and therefore impeachment must be treated as a mechanism of last resort. In their view, a mere transposition of the presidential framework through standing orders is inadequate and constitutionally insufficient. The respondents countered that with necessary modification is nothing more than a drafting device requiring only the mechanical substitution of president with deputy president. They maintained that the obligation was discharged through the National Assembly Standing Order 65-2 and Standing Order 79, and that the Parliament's procedural autonomy under Article 124(1) shields its internal arrangements from judicial scrutiny. We are unable to accept the respondent's construction. Taken to its logical conclusion, it renders the phrase superfluous. If the Constitution intended mere substitution, it would not have qualified the incorporation of Article 145 at all. The deliberate insertion of those words signals that the drafters anticipated substantive adaptation as opposed to a mechanical production or drafting convenience. This conclusion is reinforced by the structural asymmetry between the two offices, partly under Article 143. We do agree with the submission that a framework that ignores this distinction has not applied Article 145 with necessary modification. It has applied it without modification at all. The standing orders relied upon by the respondents do not cure this deficiency. National Assembly Standing Order 65-2 and Senate Standing Order 79 merely echo the constitutional command without discharging it. They reproduce the obligation verbatim, but provide no substantive modification at all. The county experience is instructive in this procedural questions that a comprehensive statutory framework ought to have addressed in advance. The subsequent county government's state officers' removal from office procedure bill of 2024 was Parliament's legislative acknowledgement of that inadequacy. That bill codifies due process protection, imposes timelines, mandates public participation, establishes a hierarchy between statute and standing orders, and resolves ambiguities such as the role of Senate in voting on charges regardless of committee findings. By contrast, the national framework for removal of the deputy president contains none of such safeguards. The very issues agitated in the petitions before us, including the inadequacy of public participation, the role of the special committee, procedural rights of the deputy president, timelines, and neutrality of presiding officers are precisely the questions a dedicated legislative framework would have foreclosed. Equally, the question on judicial intervention before an impeached president or deputy president is replaced would also be addressed in the legislation. Their resolution through litigation rather than legislation, and the challenges that the impeachment proceedings have brought forth is itself evidence of that lacuna. Courts do not legislate, but it is within the proper constitutional role of the courts to identify legislative gaps and invite Parliament to address them, particularly where those gaps carry the potential for constitutional crisis. We therefore find that the existing framework under Article 150 is structurally inadequate. The absence of a comprehensive structural framework does not preserve parliamentary autonomy. It transfers the resolution of fundamental procedural questions to the courts at considerable cost to institutional certainty and public confidence. We therefore hold that Parliament ought urgently to enact a dedicated statutory framework for the removal of the Deputy President under Article 150. We do observe, however, that the absence of such legislation does not invalidate the impeachment process already undertaken. This is because the Constitution itself, at Articles 144 and 145, sets out the minimum threshold for conducting such proceedings. It is upon this constitutional framework that Parliament relied, ensuring that the process was carried out in a manner designed to safeguard the Deputy President's protections. On timelines, we note that Standing Order 78-2 imposes a 10-day timeline in respect of a special committee investigation. Neither the standing orders nor the Constitution prescribes a timeline for plenary proceedings. The Senate's adoption of a 10-day deadline for its plenary hearing was therefore a self-imposed procedural choice and not a requirement of the standing orders or the Constitution. The Senate was not obligated by any applicable rule to impose that timeline when it elected to proceed by way of plenary. And the petitioners have not demonstrated that the choice to do so was in itself a constitutional violation.
I will now deal with two issues, that is the composition of the National Assembly and IBC, and the issue of the constitutional processes. I'll start with the issue of composition of the National Assembly and the IEBC. Three other issues were raised under the heading, including whether the National Assembly was properly constituted to consider the impeachment motion, whether the nomination of His Excellency Kindiki could take place in the absence of fully constituted IEBC, and whether his nomination as Deputy President was infirm. We shall address these issues in turn. The third petitioner, Honorable Jane Njeri Maina, invited this court to declare that the National Assembly, as presently constituted, was not legally constituted for failure to comply with the constitutionally two-thirds gender principle under Articles 27, 81B, 100, and 261 of the Constitution. She submitted that, as a consequence, the National Assembly is incapable of entertaining or deliberating on the impeachment motion against the Deputy President. She therefore sought declarations impugning both the legality of the National Assembly and the validity of the proceedings arising from its resolution. The respondents opposed that contention. The National Assembly and its clerk maintained that the constitutional requirements concerning the composition of Parliament under Articles 97 and 98 of the Constitution had been satisfied. They admitted that they submitted that the two-thirds gender principle did not render Parliament unlawfully constituted or incapable of functioning, and that Article 261 itself establishes the constitutional mechanism for securing compliance where legislation or implementation has lagged. They warned that acceptance of the petitioner's proposition would invalidate all parliamentary business undertaken since 2013, an outcome they described as constitutionally untenable and absurd. The Speaker of the Senate and the Senate associated themselves with that position and further urged judicial restraint, submitting that despite that the dispute concerning implementation of the two-thirds gender principle remains actively before a duly constituted 5-judge bench in Conchela and others. There can be no controversy that the two-thirds gender principle is a constitutional imperative. Article 81B decrees that not more than two-thirds of the members of elective bodies shall be of the same gender. Article 27 and Article 100 reinforce the constitutional commitment to equality, inclusiveness, and equitable representation. The courts of this country have consistently affirmed that gender principle is not ornamental constitutional rhetoric, but a binding constitutional stance that demands implementation. Equally, however, constitutional adjudication must be undertaken within the framework of the Constitution and the dispute resolution mechanisms it establishes. The question before us is not whether the two-thirds gender principle is obligatory. It undoubtedly is. Rather, the narrower and the more immediate question is whether the alleged non-compliance with that constitutional principle rendered the National Assembly illegally constituted as to deprive it of authority to entertain and determine an impeachment motion under Articles 145 and 150 of the Constitution. Article 261 of the Constitution speaks to the timelines within which legislation ought to be passed by Parliament. It also provides for the consequences of failure to pass legislation. On such a failure, a petition may be filed in the High Court, and the court may grant a declaratory order directing Parliament and the Attorney General to take steps to ensure that the required legislation is enacted within the period specified in the order, and to report the progress to the Chief Justice. In the event Parliament fails to enact the legislation in accordance with the court order, the Chief Justice shall advise the President to dissolve Parliament, and the President shall so dissolve Parliament. The new Parliament shall then enact legislation within the terms contained in the court order, lest it faces similar consequences. The issue of failure by Parliament to enact the legislation on the gender rule has been litigated in courts for relatively long. Further, in an advisory opinion filed in the Supreme Court, other petitions under Article 261 have been filed in the High Court and declarations made. The Honorable Chief Justice even advised the President to dissolve Parliament. It was that advice that elicited the institution of Conchela and others versus Chief Justice Supra. The matter was recently determined by an expanded bench of this court via the judgment delivered on the 5th of June 2026, that is last Friday, where the advice to dissolve Parliament by the Honorable Chief Justice to the President was declared unconstitutional and subsequently quashed for failure to comply with some fundamental procedural steps. The court, however, clarified that the parties were still at liberty to comply with the requisite procedural steps, and that which the law will then follow its course. Therefore, as long as the redress in Article 261 is yet to be fully realized, it will be premature for this court to declare that the National Assembly was not properly constituted to consider the impeachment motion. To that end, the contention fails. The challenge to the IBC was advanced on two related grounds. First, that IBC was constitutionally incapacitated by the absence of commissioners at the material time, such that any verification of His Excellency Kindiki's qualifications being a substantive commission-led function under Article 250, Sub-Article 1, could not lawfully be performed by the Secretariat alone. And second, that the clearance process was consequently a nullity that fatally infected the nomination. The respondents, however, maintained that the midterm replacement mechanism under Article 149, Sub-Article 1, was a sui generis self-executing constitutional process that did not engage the IBC electoral mandate under Article 88, Sub-Article 4, and that the strict eligibility and clearance protocols under Articles 99 and 137 applied exclusively to general elections and not to midterm nomination vetted directly by the National Assembly. Our reading of Article 149, Sub-Article 1, confirms that it is unambiguous, express, and self-contained. It establishes a strict executive legislative process where the President nominates and the National Assembly votes on the Deputy President nominee. It makes no reference to IEBC. That omission is not an oversight. It is a deliberate constitutional choice which this court must give full effect. Were it the intention of the drafters to impose a more stringent requirement, nothing would have been easier than to say so expressly, as they did in Articles 99 and 137 in respect to candidates for elective office at a general election. The absence of any equivalent requirement in Article 149, Sub-Article 1 is therefore a considered constitutional choice to be respected. For ease of reference, Article 149, Sub-Article 1 provides as follows, and I quote, vacancy in the office of Deputy President. Within 14 days after a vacancy in the office of Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. From a plain reading of the above, we are convinced that no clearance was required by the Deputy President, and that the vote by the National Assembly was an expression of representative authority by the sovereign's elected representative, precisely the constitutional mechanism that Article 149, Sub-Article 1 contemplates. Under Article 1 of the Constitution, sovereign power belongs to the people of Kenya and may be exercised either directly or through their democratically elected representatives. When the National Assembly voted on His Excellency Kindiki's nomination, it did so as the constitutional repository of delegated sovereign authority acting on behalf of the people in accordance with the specific mechanism the Constitution provides for filling in a midterm vacancy in the office of the Deputy President. We equally accept the respondents' submissions that on the deliberate use of the word vote in Article 149.1 as opposed to the words approve or vet, that the Constitution employs in other contexts. That distinction is constitutionally significant. Across the Constitution, we note that the word approve is used where Parliament exercises a confirmatory function in relation to executive appointments, as in the approval under Article 132, Sub-Article 2 of Cabinet Secretaries, the Attorney General, the Secretary to the Cabinet, the Principal Secretary, the High Commissioners, Ambassadors, and diplomatic consular representatives, as well as any other state or public officer whom the Constitution requires or empowers the President to appoint or dismiss. The same applies to the approval of the candidates for constitutional offices such as the Chief Justice under Article 166 of the Constitution. In those contexts, approval connotes a deliberate and structured vetting exercise in which Parliament assesses the suitability of the nominee against a prescribed criterion, and in which the IBC or other constitutional bodies may have a role to play in verifying qualifications. The word vet carries similar connotations of structured scrutiny against defined standards. The word vote, by contrast, denotes a direct and immediate exercise of collective democratic will. It is the language of elections and of sovereign determination. Its use in Article 149, Sub-Article 1, signals that the National Assembly's function in the midterm replacement process is not to sit in the judgment of the nominee's suitability, but to exercise on behalf of the people a direct democratic determination on whether the president nominee should fill the vacancy. That determination is political and representative in character, and it is expressed through the ballot of elected members of Parliament, each of whom is accountable to their constituents for the vote they cast. It consequently follows that no input or intervention by the IBC was constitutionally required in the midterm replacement process under Article 149(1). The absence of any IBC involvement would not have rendered the nomination or the filling of the vacancy unconstitutional. The informational input by the IBC Secretariat did provide was, in those circumstances, entirely voluntary in character. It was not a condition precedent to the validity of the process, and its presence or absence was constitutionally irrelevant to the outcome. That being so, the fact that the input was provided by the Secretariat in the absence of commissioners is equally irrelevant if the input was not required at all. The question of whom within the IBC provided it simply does not arise. For completeness, however, and to the extent that any residual question remains about the lawfulness of the Secretariat's involvement, we are satisfied that the informational verification performed by the Secretariat could not have constituted a clearance in the electoral sense, but rather a routine administrative task, and as such not constitutional or policy-driven. The same was legally permissible and procedurally valid and fell squarely within the Secretariat's lawful administrative mandate. We draw from the advisory opinion number 4 of 2024, IBC, and the Honorable AG, where the Supreme Court gave guidance on the dichotomy that exists between the role of the commissioners and that of the Secretariat in the following words. And I quote, "The Secretariat, under the leadership of the Commission, Secretary and the CEO, is empowered to undertake routine administrative and operational tasks essential for the day-to-day functioning of the Commission. In the same vein, it is necessary to clarify that the absence of commissioners does not of itself vitiate or invalidate administrative actions taken by the Secretariat within the scope of its lawful mandate, including the execution of contracts, management of personnel, procurement, and other functions necessary for institutional continuity. Such acts remain valid and binding, and provided they fall within the bounds of statutory delegation and do not purport to usurp the constitutional function of the Commission as a corporate body," end of quote. To guard against institutional overreach, the Supreme Court carefully delineated where IBC's administrative mandate ends as follows, and the court, once again, having concluded as above, a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It is our considered view that the exercise of constitutional function expressly reserved for Commission, such as those enumerated under Article 88, Sub-Article 4 of the Constitution, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum as contemplated under Article 250, Sub-Article 1 and Sub-Article 2 of the Constitution, end of quote. This differentiation of responsibility is further contained in Section 11A of the Independent Electoral and Boundaries Commission Act and exposed by the Supreme Court in the Muruli versus Oparanya and 3 others case. For all these reasons, it is our finding that the Secretariat did not travel beyond its mandate. It simply functioned as an information repository. Having so found, we now move to the last sub-issue concerning the constitutional validity of His Excellency Kindiki's nomination. The petitioners anchored the ground on Article 148, Sub-Article 1, read with Article 137, contending that His Excellency Kindiki was serving as Cabinet Secretary for Internal and National Administration, a state office under Article 260, at the time of his nomination and parliamentary approval on the 18th of October 2024. He was disqualified from nomination by dint of Article 137, Sub-Article 2B, rendering the entire process null and void ab initio. In contrast, the respondents who responded to this ground argued that the appointment process was completely legal and procedurally sound. They maintained that the filling of midterm vacancy under Article 149, Sub-Article 1 was an independent sui generis executive-led process, and that was distinct from traditional election or appointment. Further, it was the case that the restrictive disqualification in Article 137, such as the recruitment to the requirement to resign 6 months prior to or to secure multi-county voter endorsement, were tailored exclusively for general elections, not sudden midterm vacancies that demanded swift action to prevent a leadership vacuum. They contended that the initial formation of a presidential joint ticket under Article 148 could not apply to midterm emergency transitions. In addition, His Excellency Kindiki and the IBC specifically disputed the factual basis of the petitions, arguing that His Excellency Kindiki had in fact provided official gazette notices proving he had formally resigned from his cabinet position prior to his appointment as Deputy President. In considering the arguments of both parties, we turn to the relevant constitutional provisions, to wit Articles 137, 148, and 149. Article 137, Sub-Article 2B, bars any person who is a public officer or is acting in any state or other public office from nomination as a presidential candidate. Article 137, Sub-Article B, carves out exemptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, Sub-Article 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, Sub-Article 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, Sub-Article 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, Subarticle 1, and Article 137, Subarticle 2b together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, Subarticle 1, creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, Subarticle 1, omits the standard electoral requirements, including the signature collection requirement, and Article 137, Subarticle 1d, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, Subarticle 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, Subarticle 2b, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking oath of office as deputy president. By severing his ties to the cabinet before assuming the deputy presidential office, the potential conflict of interest under Article 137, Subarticle 2b is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue, we must address whether the speed with which the state resolution, with which the Senate resolution was gazetted, the President nominated Professor His Excellency Kindiki, and the National Assembly approved the nominee, contravened the Constitution and the law. The petitioners argued that the extraordinary haste following the Senate's resolution of 17th of October 2024 revealed a predetermined impeachment process. In their view, the immediate gazettement, swift presidential nomination, and expedited parliamentary approval were evidence of a prearranged outcome. They contended that such speed undermined constitutional values of transparency, accountability, public participation, fairness, and constitutionalism. The respondents, including His Excellency Kindiki, took the opposite position. They maintained that the Constitution itself anticipates expedition in matters concerning high constitutional office. Once a vacancy arose in the office of the Deputy President, they argued the President was constitutionally bound to act under Article 149. Prompt compliance with such a duty, they insisted, cannot be itself amount to constitutional impropriety. Turning to the Constitution, Article 149(1), we have already reproduced that section, that article. I don't need to go through it again. Proceed. This provision leaves no doubt that the framers of our Constitution deliberately contemplated speed in filling in a vacancy of the Deputy President's office. The rationale is evident, and it is to safeguard continuity and the stability in the national executive by requiring prompt action. Judicial President reinforces this principle. In Ali Hassan Joho and another was a Suleiman Said Shabal, and others. This is a Supreme Court petition number 10 of 2013. The court held that constitutional timelines are substantive requirements, not procedural conveniences, and cannot be extended by legislation or judicial discretion. Similarly, in the Mankin Aramat versus Harun Meitamei, Lenpaka, and two others, the Supreme Court, it's a Supreme Court matter petition. The court emphasized that constitutional timelines are binding commands, cautioning against reliance on Article 159 to circumvent them. The same principle was affirmed in Moses Masika Wetangula versus Muskari Kombo, Muskari Nazi Kombo, and two others, and in Harun Meitamei Lempaka versus Lempakian Aramat, where the Court of Appeal underscored the constitutional significance of timelines. Collectively, these authorities highlight that timelines serve vital public interests, including certainty, legitimacy, and orderly governance. The Supreme Court's decision in Raila Odinga and five others versus Independent Electoral and Boundaries Commission and three others, this is presidential petition number 5 of 2013, is also instructive. Addressing timelines under Article 140, the court had the following to say, and I quote, according to Article 140 of the Constitution, it is clear that in the resolution of presidential election disputes, I repeat that. According to Article 140 of the Constitution, it is clear that expedition in the resolution of presidential election disputes is of essence, end of quote. The court warned that prolonged uncertainty regarding the presidency undermines public interest. This reasoning reflects a broader constitutional philosophy that uncertainty in the occupants of high office is detrimental, and the Constitution deliberately establishes mechanisms to ensure continuity. Applying these principles, we are not persuaded that the prompt gazettement of the Senate's resolution was unconstitutional. Once the Senate concluded its process, the Deputy President ceased to hold office, and nothing in the Constitution required a waiting period before gazettement. Likewise, the President cannot be faulted for acting swiftly under Article 149. He was constitutionally obligated to nominate a replacement within 14 days. Compliance with this duty cannot be construed as wrongdoing. To hold otherwise would penalize constitutional actors for fulfilling their obligations. The same reasoning applies to the National Assembly. Article 149 allows up to 60 days to vote on a nomination, but it does not require Parliament to exhaust that period. Acting sooner than the deadline is not evidence of illegality. Speed alone does not establish predetermination. The law requires objective proof that a decision maker had closed their minds before exercising power. Mere expedition does not meet that threshold. We therefore find that the gazettement of the Senate resolution, the President nomination of His Excellency Kindiki, and the nomination National Assembly's approval did not contravene the Constitution simply because they were undertaken expeditiously. I will now turn to the constitutional processes. Under this heading, this court is called upon to interpret Articles 144 and 145 of the Constitution to determine whether the Senate was obligated to establish a special committee to investigate the charges against the Deputy President, or whether the formation of such a committee was discretionary. The court is equally invited to examine the procedures applied in the impeachment process, with particular focus on Article 150, sub-Article 2, and the extent to which, if at all, the Senate ran afoul the Constitution in that respect. Starting with the first issue, the dispute before us brings into sharp focus the jurisprudential tension embedded in Article 145 of the Constitution, and more particularly, Article 145, sub-Article 3b, of the Constitution. Article 145, subarticle 2 and subarticle 3 detail the provision of removal in the following terms. I do not need to read those ones, those provisions. I proceed. The true import of clause 3B cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of historical continuum just a minute. Yes, I proceed. The true import of clause 3B cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of the historical continuum of Kenya's constitutional reform. Constitutional interpretation, particularly in matters touching on the architecture of the governance, must be informed by history, for history illuminates the intent of the framers, constitutionalizes the text, and guards against distortion that arise from reading provisions in a vacuum. As the courts have consistently held, Constitution is not merely a legal instrument, but a living charter whose meaning is entrenched by the struggles, compromises, and aspirations that birthed it. Accordingly, this inquiry necessitates tracing the evolution of impeachment clause through the Bomas draft, the Wako draft, and the harmonized draft to appreciate the context of Article 145, subarticle 3B was ultimately incorporated into the Constitution. Article 164 of the Bomas draft outlined the procedure for impeachment, vesting the Senate with ultimate authority. It provided that upon receipt of a resolution from the National Assembly, the Speaker of the Senate would convene the Senate, and if the motion was passed, a special committee of the 13-member will be appointed to investigate the matter. The language of the Bomas draft was rigid and prescriptive. The investigatory phrase was mandatory, and the committee route was the inescapable mechanism for digesting evidentiary complexities prior to a final vote. If the committee found the allegations unsubstantiated, no further proceedings would ensue. For avoidance of doubt, it provided as follows. The Speaker of the Senate shall, if Senate is then sitting or has been summoned to bring the motion to the notice of the Senate for the consideration within 7 days, or if Senate is not then sitting, will summon it to meet within 21 days of the motion, 21 days of the notice to consider the motion. If a motion is passed under clause 3, the Senate shall appoint 13 of its members as a special committee in accordance with its standing orders of the Senate to investigate the matter. If the special committee shall investigate the matter and shall, within 10 days, report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. End of quote. Similarly, Article 155 of the Wako draft mandated the formation of a special committee of 13 members of Parliament to investigate allegations once an impeachment motion was initiated. The provision was explicit and inflexible, leaving Parliament with no discretion. The committee route was compulsory, and the President retained the right to appear and be represented before the committee. For clarity, we have reproduced that one as well, but I will not go through it. I proceed. The harmonized draft of 2009 and its subsequent revision in 2010 represents the constitutional settlement now embodied in Article 145, which is the subject of contestation before us. To our mind, there appears to have been a deliberate harmony in the manner the previous drafts treated the committee stage of the impeachment proceedings. We are convinced that the framers intended to preserve this consistency across the drafts rather than to depart from it. This conclusion is fortified by a wholesome reading of the Constitution, which we explain in detail. Interpreting the text before us requires a careful and nuanced exercise in constitutional interpretation. Fortunately, the Constitution itself provides guidance on how it should be read. Articles 20, Subarticle 4, and Articles 259, Subarticle 1 establish the interpretive framework. Article 20, Subarticle 4 directs courts when interpreting the Bill of Rights to promote the values of an open and democratic society founded on human dignity, equality, equity, and freedom, while giving effect to the spirit and the objects of the Bill of Rights. Article 259, Subarticle 1 further commands courts to interpret the Constitution in a manner that advances its purpose, values, and principles, threatens the rule of law, protects human rights and fundamental freedoms, permits development of the law, and contributes to good governance. Over time, our courts have consistently emphasized that the 2010 Constitution demands a transformative approach to interpretation. Recognizing its highly progressive nature, courts have articulated several interpretive canons. In David D. and others, such as AG, the High Court, that is the BBI case, the High Court identified 4 guiding principles: that the Constitution must be interpreted holistically, that it should not be approached with rigid formalities or treated as a mere statute, that its own theory of interpretation must be applied to safeguard its values, objects, and purpose, and that non-legal considerations are essential to uncover the true meaning and values. The Supreme Court, in the matter of Kenya National Commission on Human Rights 2014, clarified that a holistic interpretation requires contextual analysis, which means reading provisions alongside and against each other, informed by history, disputes, and prevailing circumstances. Similarly, in the Tunyefuza versus AG case, this is a Ugandan court, stressed that a constitution must be read as an integrated whole with each provision sustaining rather than undermining the others. The principle that the Constitution must not be interpreted through rigid formalism was also emphasized by the Supreme Court in Interim Independent Electoral Commission 2011 and the Communication Commission of Kenya versus Royal Media Services 2015. The court observed that constitutional interpretation requires more than positivistic approaches. The court noted that Articles 20, Subarticle 4, and Articles 259, Subarticle 1 incorporate non-legal considerations such as historical, social, cultural, and political realities that must inform judicial reasoning. The court highlighted that Kenya's modern Bill of Rights envisages a human-based approach and social justice-oriented society, and judicial authority derived from the people under Article 159, Subarticle 1 must reflect these values in court decisions. The former Chief Justice Emeritus Mutunga, in his concurring opinion in the Speaker of the Senate and another versus the AG, this is 2013 reported, also underscored the constitution making was an ongoing process, and acknowledged that compromises in drafting often create vagueness, and it is the court's responsibility to resolve contradictions and clarify gaps. In his words, I quote, "Constitution making does not end with the promulgation. It continues with the interpretation. Finally, the Court of Appeal in Center for Rights, Education and Awareness, and another versus John Harun Mwau, 2012 reported, linked constitutional interpretation with the statutory interpretation principles. It reiterated that courts must avoid absurd, unpracticable, illogical, and artificial results and must always strive to serve the public interest. Fidelity to both the letter and the spirit of the Constitution requires interpretations that advance justice, rationality, and the common good. Guided by the interpretive principles discussed above, we now turn to examine the purpose and the intent of Article 145, Sub-Article 3 of the Constitution. We do so with full appreciation of the demands of judicial humility and the doctrine of stare decisis, which binds inferior courts to the pronouncements of superior ones and is the bedrock of coherent and predictable legal order. Our analysis is therefore offered within that framework, not as a departure from it. We are aware that the Supreme Court has determined the question in the Sonko decision, and we are mindful that the suggestion we are advancing in this discussion will build upon the existing jurisprudence and contribute to the broader legal discourse on this question. It is in that spirit and with deference owed to the Supreme Court that we nonetheless set out the following reasoning. Having already traced the historical development of this provision, a comparison of the earlier drafts with the current text reveals a consistent approach to the introduction of a removal motion from the National Assembly. In every instance, the motion was to be formally tabled for consideration. The draft made clear that once introduced, the motion will be debated and if passed, the special committee constituted. This framework is now embedded in Article 145(3)(a) of the 2010 Constitution, which expressly obligates the Senate to convene and or hear the charges against the President. These charges are the charges as contained in the removal motion transmitted from the National Assembly pursuant to Article 145, Sub-Article 2. It is only after the Senate has heard the charges that Article 145, Sub-Article 3b comes into play. It is important to note that the motion was never intended to be passed or dismissed as a mere formality. The House was called upon to consider, debate, and to resolve whether the motion should proceed or fail. If the motion failed, that marks the end of the matter, and no further proceedings will follow. Conversely, if Parliament determined that the matter warranted investigation, it passed a resolution allowing the impeachment motion to proceed, and a special committee is then formed. Returning to Article 145, Sub-Article 3A, upon receipt of the removal motion, the Senate is required to hear the charges. While this hearing may not necessarily connote a formal trial, it provides an opportunity for the House to be appraised of the charges, the supporting evidence, and any accompanying documentation. At this stage, the Senate must decide by resolution whether the charges merit investigation. It is also at this point that the House considers whether the other preliminary requirements, such as the constitutional threshold, were properly satisfied by the National Assembly in the first place. We have examined the Hansard record of the Senate sitting on Wednesday, the 9th of October 2024, convened pursuant to Kenya Gazette Notice number 13170. The record shows that the Honorable Speaker of the Senate duly appointed the session for the purpose of hearing the charges against the then Deputy President. During the sitting, the Speaker read out all 11 charges and formally laid before the Senate the documents conveying the resolution of the National Assembly. These materials included the notice of special motion, affidavit of Honorable Ekoman Mwengi Mutuse, MP, electronic evidence relating to the motion, order papers, communications from the chair, certified Hansard record, votes and proceedings, public participation notices, correspondences from the advocates, press statements, court orders, and other supporting documentation. The Honorable Speaker proceeded to draw the attention of the House to the special and the unique nature of the business before it. It reminded senators that impeachment is a fundamental tool of legislative oversight and a critical component of the constitutional framework of checks and balances, noting further that the matter had attracted immense public interest. The Speaker then outlined the way forward, informing the House that by its resolution, it had two options of handling the motion, either through a special committee or in plenary. Significantly, the procedure adopted by the Speaker reveals that once the charges and supporting evidence were laid before the House, there was no opportunity for senators to deliberate on whether further investigations were necessary. In particular, the House was not afforded the chance to engage in a substantive inquiry into the propriety of the process undertaken by the National Assembly or the validity of the charges themselves. The question that now arises is whether it was necessary for the Senate, in the first instance, to address itself to the need for investigations before proceeding to the actual hearing of the motion. It must be emphasized that the Senate is not a mere conveyor belt for the matters originating from the National Assembly or any other entity. Rather, it is a revered house vested with autonomy and empowered to make decisions by way of resolution. The Senate, therefore, retains discretion to determine whether to accept any motion, petition, or request for further deliberation, save in circumstances where the Constitution or statute expressly removes such discretion. This explains why the earlier drafts of the Constitution stipulated that a motion had to be passed before a special committee could be formed. The design was deliberate. The House was first required to decide whether the motion should pass or fail, and only upon passage will the question of constituting a special committee arise. A useful instruction of this principle is found in the legislative process. Not all legislation automatically passes to the Senate. Article 114, for example, requires the Senate to consider whether a bill transmitted from the National Assembly falls within its jurisdiction and warrants deliberation in the House. Article 145, subarticle 3b, is therefore not unique in this regard. It was intended to give the Senate an opportunity to hear the charges, examine the evidence, and satisfy itself that at least the bare minimum constitutional and statutory requirements had been met on a prima facie basis. In doing so, the Senate would address fundamental preliminary issues, such as whether the grounds of the special motion fall within those provided for in the Constitution or law, whether the jurisdiction had been properly invoked, whether the president was previously tried on the same charges, whether prima facie evidence supports the charges, and whether the requisite threshold was attained in the National Assembly. It is only after the Senate has addressed these preliminary issues that it proceeds to take a vote by way of a resolution on whether to admit the motion for a full hearing or to defeat it. This explains the deliberate use of the word may in Article 145, subarticle 3b. The term may signifies discretion on the part of the Senate to determine whether the motion, as presented, satisfies the minimum constitutional and statutory requirements and therefore warrants further consideration. Once such a resolution is made and the Senate decides to proceed, the House then turns to the procedure governing the hearing. Conversely, if the Senate is not satisfied that the motion merits further interrogation, the matter ends there. There is therefore no ambiguity in the use of the word may in Article 145 3b. It clearly connotes discretion and cannot be equated with the mandatory term shall. The true meaning and intent of Article 143b can only be appreciated in light of that historical context. To interpret the provision in isolation would risk stripping the Senate its discretion to determine what matters it can lawfully consider. This position finds support in the commentary of legal scholars Louis Franceschi and Pierre Lumumba in the book Constitution of Kenya, a documentary, second edition 2019, where they stated as follows, and I quote, "In order to avoid abuse of Parliament's power to impeach a president, the Constitution appropriately provides for 2/3 majority threshold of the total number in both houses of Parliament. Furthermore, the Senate is called to constitute a special committee to investigate the charges against a president and present a report as opposed to just voting at the National Assembly. In order to ensure fairness of the Senate's committee proceedings, the president has the right to appear and be represented before the special committee during its investigation," end of quote. Upon careful perusal of the Senate Hansard, however, we did not find any debate or proceedings or resolution indicating that the House interrogated the motion as presented from National Assembly or resolved on the way forward. The record shows that once the motion was laid before the House, the charges were read out and the supporting evidence tendered. That was all. No resolution admitting the motion to a full hearing was made. The Senate instead proceeded to address, directly to address itself on the issue of the charges to be had. In our view, going by our rendition, we will not have approved this way forward. Having so established, we take the position that once Senate resolves to admit and proceed with the hearing of the motion, its discretion is spent. The only cause available is to appoint the special committee to investigate the matter. This conclusion flows naturally from the foregoing discussion and from the deliberate manner in which sub-articles 145, sub-article 4, 5, and 7 are structured. These provisions build upon the process once the special committee is constituted, setting out the subsequent stages of investigation and the right of the Deputy President to appear and be represented before the committee, the tabling of the committee's report before the plenary, a second opportunity to the Deputy President to be heard, and finally, the Senate's vote. We ask ourselves, if the intention had been to follow a direct plenary route, why would the drafters not have said so? Why would they have crafted such a detailed provision for the committee process, only to mention the Senate at the tail end of that process? The deliberate sequencing of sub-articles 145, 4, 5, 6, and 7 leaves no doubt in our minds that the committee mechanism was intended to be the exclusive path once the Senate resolved to proceed. The plenary option was never envisaged as a substitute for the committee process, but rather as the forum for receiving and debating the committee report. To hold otherwise, according to us, will create an absurdity in which the Senate as a house would investigate and then present to itself the investigative report for voting. At the risk of repetition, but for emphasis, we observe that the removal of the president by way of impeachment was not provided for in the retired 1963 Constitution, save for this superficial vote of no confidence. Kenyans were therefore deliberate in crafting a detailed procedure for the hearing of an impeachment motion under the 2010 Constitution. This procedure is well captured in the sub-articles to Article 145, which specifies the number of members to be appointed to the special committee, the committee's role in investigating the charges, and the strict timeline of 10 days within which the committee must act. Sub-Article 145(5) further commands the observance of the two distinct rights of the President. First, the right to appear before the committee personally, and second, the right to be represented. These rights are not synonymous. The right to appear is exercised by the President as an individual, whereas the right to be represented allows the President to appear alongside counsel or to have counsel appear on his or her behalf. These two rights must be juxtaposed with the right provided for in sub-article 145(6)(b), which grants the President an opportunity to be heard at the plenary once the committee finds any of the charges substantiated. This right is again distinct, as an opportunity to be heard is not limited to physical or oral hearing, but encompasses the broader ability to present a defense in whatever form the Senate deems appropriate. This interpretation ensures a generous reading of the rights of the President, who is afforded representation and opportunity to be heard both at the committee stage and again before the plenary. Such a generous interpretation is precisely what the Constitution commands. For all the foregoing reasons, we do find that just a minute. Having expressed our view, we again differ unreservedly and with the deepest respect to the binding authority of the Supreme Court as settled in Soko versus County Assembly of Nairobi, where the court pronounced itself as follows. I quote, "In the previous ground 2 above, we categorized the process of removing a governor into 2 stages. This is the second stage. From subsection 3 of Section 33 of the County Government Act, the process moves to the Senate from the County Assembly. Within 7 days after receiving notice of a resolution from the Speaker of the County Assembly confirming the passage of the impeachment motion, the Speaker of the Senate must convene the meeting of the Senate to hear the charge against the governor. The charges can be heard in the Senate plenary or in a forum of a special committee of the Senate that reports to the full Senate. In either case, the governor is entitled to attend and to be represented by counsel during the investigations. It is only when sufficient evidence is presented to substantiate the claims that the Senate will according the governor an opportunity to be heard, vote on each of the charges. If a majority of all the members of the Senate vote to uphold any of the charges, then the governor shall cease to hold office. We reiterate that proof of even a single charge will be sufficient for purposes of Article 181 of the Constitution. But should the vote for removal fail, that brings the proceedings to an end. End of quote. That pronouncement represents that settled and binding position of law. We are constitutionally obliged to follow it, and we do so without reservation, notwithstanding the views which we expressed above. We observe in passing that although the Supreme Court pronouncement in Sonko was referred in the context of interpreting the County Government Act, the provisions of the Act mirror the virtual identical terms, the language of the Article 145 of the Constitution. That correspondence reinforces its application to the present matter.
We now move to the final issue that we considered, and that is the issue of a fair trial. The gist of this issue turns on whether His Excellency Gachagua was subjected to a lawful and fair trial process within the meaning of Articles 47 and 50 of the Constitution. The petitioners contended that the Senate's conduct of the impeachment trial was fundamentally and irreparably flawed, falling far short of the constitutional standards of fairness, legality, and procedural propriety granted to His Excellency Gachagua under the stated provisions. Their challenge on this ground was advanced on several distinct and cumulative bases. They argued that His Excellency Gachagua was denied his right to a fair trial when, having fallen ill and being hospitalized on the 17th of October 2024, the Senate refused adjournment request and proceeded in his absence, ultimately voting on 5 of the impeachment charges. That the Senate was constitutionally bound under Article 145(3)(b) and 145(4)(6) to appoint a special committee of 11 members to investigate the charges. By defeating the motion to establish such a committee and proceeding by plenary, the Senate deprived him of his right under Article 145(5) to appear and be represented before an independent investigative body. Insulated from political pressure, and that the time afforded to H.E. Gachagua was grossly inadequate, only a few days to respond to 11 complex allegations and just 2 hours to present his defense compared to the extensive time given to the National Assembly. The respondents in defense maintained that the Senate had accorded His Excellency Gachagua a lawful and fair trial consistent with Articles 47 and 50 of the Constitution, that the Senate acted reasonably by granting a short adjournment and offering a further extension to 19 October 2024, and when the formal motion was defeated, they submitted that discretion had been properly exercised, especially since no medical evidence was produced. They maintained that the Constitution conferred discretion to proceed by way of a special committee or plenary under Article 145(3)(b), and denied that new evidence or witnesses were introduced at the Senate stage as alleged by H.E. Gachagua. We have carefully considered the forcefully and ably argued positions advanced by both sides. The constitutional standard which the fairness of the Senate conduct falls to be measured is clearly and comprehensively set out in Article 50 of the Constitution. Of particular relevance to the present inquiry are the following guarantees, which Article 50 confers on every accused person as components of the right to a fair trial. Under 50C is the right to have adequate time and facilities to prepare a defense. F, to be present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. And K, to adduce and challenge evidence. These guarantees do not stand alone. They are reinforced and complemented in the specific context of impeachment proceedings by the procedural rights expressly conferred by Article 145(5) and 145(6)(b) of the Constitution, which provide as follows. 5. The President shall have the right to appear and be represented before the special committee during its investigations. And in 6b, that Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. To the foregoing must be added Article 47 of the Constitution, which guarantees every person the right to fair administrative action that is lawful, reasonable, and procedurally fair. That right is not confined to purely judicial proceedings. It attaches to any exercise of public power that affects a person's rights, interests, or legitimate expectations, and it applies with full force to the impeachment process before a decision to remove is taken. The Supreme Court in Sonko reaffirmed this position, holding that during the process of removal, both the right to fair administrative action under Article 47 and the right to a fair hearing under Article 50 accrue to the office holder whose removal is sought. This court reads that holding as applying with equal force to His Excellency Gachagua in the present proceedings. The Supreme Court further held that while impeachment is a political process, it is equally subject to constitutional discipline and the principles of natural justice, and that courts will not interfere with the merits of Parliament's decision unless a violation of fair hearing rights or procedural improprieties established. These two propositions together define both the standard the Senate was required to meet and the scope of this court's supervisory jurisdiction in assessing whether it did so. Against that framework, we turn to the specific circumstances of the present case. It is clear that during the proceedings, the National Assembly, as the prosecuting party in the Senate proceedings, presented its case through witnesses who were examined in chief and subjected to cross-examination in the full and formal sense of adversarial proceedings. There is no controversy about this fact. The petitioners contend that the Senate's refusal of the adjournment application denied His Excellency Gachagua equality of arms and equal protection of the law by preventing him from participating in the oral proceedings at the precise stage when his own evidence was to be led. The constitutional right to equality of arms has been expressly affirmed by the Court of Appeal in Olo versus Kisumu County Assembly Service Board and another, when the court cited with approval the following passage from Pinnacle Project Limited versus Presbyterian Church of East Africa, Gong Parish, and another. I quote, "Fair trial in civil cases includes the right of access to a court, the right to be heard by a competent, independent, and impartial tribunal, the right to equality of arms, the right to adduce and challenge evidence, the right to legal representation, the right to be informed of the claim in advance before the suit is led, the right to a public hearing, and the right to be heard within a reasonable time." The question in the present case is not whether H.E. Gachagua was given any opportunity to be heard. From the evidence before us, he was. The precise and constitutionally significant question is whether, having been partially heard, the remainder of his participation was unlawfully curtailed at the point when the opposing party had already completed a full adversarial presentation. The National Assembly had presented its case in its entirety, its witnesses had testified, been examined, and cross-examined. His Excellency Gachagua had not completed his. It was at that precise point of procedural imbalance, with the scales of participation tilted irrevocably in favor of one party, that the Senate refused the adjournment and proceeded to vote. That is not a case of a party who was heard and then outvoted. It is a case of a party who was prevented from completing his hearing after his opponent had completed his. What we heard the petitioners to be saying is that His Excellency Gachagua critically was not merely a respondent who had filed documentary evidence. He was, on the uncontroverted evidence before this court, his own sole witness. He was the only person who could speak to the facts from his own personal knowledge, give a first-hand account of the allegations before him, and submit himself to cross-examination in a manner that would have allowed the Senate to assess his credibility directly. The respondents relied on the Court of Appeal's decision in Kenya Revenue Authority versus Murgani, a 2010 decision, for the proposition that fairness does not always require an oral hearing, and that provided a body achieves the degree of fairness appropriate to its task, the manner in which it proceeds was a matter for its own institutional judgment. Drawing on local government vote versus Aldridge, as well as the case of Selvarajan versus Res Relations Board and R versus Immigration Appeal Tribunal, the Court of Appeal in the Murgani case concluded that a hearing conducted by way of written exchange may, in appropriate circumstances, constitute a fair hearing. We do accept that general principle as binding on us. However, Murgani is plainly distinguishable on the facts and context that are both material and decisive. That case concerned an administrative determination in which no oral proceedings had been conducted at all. Both parties were in a position of formal procedural equality. The written process was the established mechanism, and the question was simply whether the absence of an oral hearing was fatal to fairness. The present case is fundamentally different. The Senate did not choose at the outset to proceed by way of written submissions alone. It had agreed to a fully adversarial oral hearing with witnesses, examination in chief, and cross-examination. Having adopted that mode of proceeding, the Senate could not, at the moment His Excellency Gachagua was to take the stand as his own sole witness, abandon the adversarial framework it had established for itself without satisfactory reason. To do so was to apply different procedural standards to the two parties. That disparity is the antithesis of equality of arms and is irreconcilable with the constitutional guarantees of Article 47 and Article 50. The Hansard record of the Senate proceedings of 17 October 2024 confirms that following the confirmation by Paul Mwita Senior Counsel to the House that His Excellency Gachagua had been taken ill, several senators who rose to comment explicitly acknowledged on the floor of the Senate that H.E. Gachagua was unwell. Not one of these senators disputed the illness. They acknowledged it and then proceeded, notwithstanding that acknowledgement, to oppose the adjournment application. The circumstances must also be taken within the directions issued by the Speaker of Senate at the time. The Honorable Speaker stated in part as follows, I quote, "As this process is time-bound by the Constitution, to be concluded in not more than 10 days pursuant to Article 145 as read, together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it is so obliged, the requests for adjournment sought by counsel for the Deputy President would be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Honorable Senators, ladies and gentlemen, such a request is not made to the Speaker but to the Senate and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter. this being the last day allowed by the Constitution of Kenya for these proceedings to conclude. I close the quote. The Speaker's communication meant that it was in fact open to Senate to adjourn the sitting up to Saturday. The significance of that course of conduct cannot be overstated. The Senate, despite having the option to adjourn and having expressly acknowledged the incapacity of the party before it, nonetheless proceeded to determine his fate in his absence. That was not a proper exercise of constitutional discretion. It was a negation. We are convinced that had the Senate exercised its discretion genuinely, open-mindedly, and with a conscientious regard for the constitutional rights of His Excellency Gachagua, and had it directed its mind to the miscarriage of justice that its refusal was plainly going to occasion, this was a case in which the circumstances unambiguously called for an adjournment to be granted at least to the next day. That conclusion is firmly supported by the Court of Appeal's pronouncement in Kariuki versus Attorney General, a 2014 decision, where the court held as follows, again I quote, while bearing in mind that whether to grant an adjournment or not is discretionary, and appellate courts are loath to readily question the exercise of discretion by the trial court, nevertheless, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of applications for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right and the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. In denying the appellant's application for adjournment, the court-martial in that particular case also did not address its mind to the critical question of whether denial of the adjournment would occasion a miscarriage of justice. In Job Obanda versus Stage Court International Services Limited and another, this court, that is the Court of Appeal, was emphatic that where, amongst others, a judge fails to apply his mind to the question whether a miscarriage of justice might be occasioned to a party who is refused an adjournment, that would constitute sufficient basis upon which an appellate court would be entitled to interfere with the exercise of jurisdiction, close of quote. We say so with a full appreciation of the non-derogable nature of the right to a fair trial. It is not a right that yields to constitutional timelines or political exigencies. It is an absolute constitutional guarantee, and its violation cannot be justified by reference to any competing constitutional interest, however weighty or pressing that interest may be. This finding becomes even more compelling when one considers the Senate's misdirection in its interpretation of Article 145(4)(b). Senate appeared to imagine that it had 10 days within which to dispense the impeachment hearing itself. Yet, the text and structure of that provision, according to us, make it clear that the 10-day period was intended to apply exclusively to the special committee once constituted. We have addressed in detail our understanding of Articles 145(3)(b) and 145, sub-article 4 to 6 in the preceding section of this judgment, and we do not propose to repeat that analysis again here. Finally, we wish to make brief observations on the affidavit of Dr. Daniel Kibuka Gikonyo, sworn on the 28th of April 2026, which was admitted into evidence by leave of this court and tested by cross-examination when Dr. Gikonyo attended to give oral testimony. There is no doubt that the affidavit was not before the Senate on the 17th of October 2024 when the request for adjournment was made. And on that ground, we do agree with Senate's submission that it could not have informed the House's determination at the time. The affidavit was additionally filed almost 2 years after the petitions were instituted, and no explanation was offered to us, including by Dr. Gikonyo himself, for that delay. For those reasons, we do not attribute significant probative value to it. The circumstances, as we have analyzed, were independently and collectively sufficient to warrant a reasonable adjournment. Dr. Gikonyo's evidence neither adds nor detracts from that conclusion.
In conclusion, therefore, upon careful consideration of the consolidated petitions, the responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution, the President's nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution merely because they were undertaken expeditiously. We therefore affirm that the nomination and appointment of His Excellency Kindiki as Deputy President was valid. Constitutional processes. We find that Parliament ought to urgently enact a dedicated statutory framework for the removal of the Deputy President under Article 150. The phrase, in quote, with the necessary modifications, is a substantive constitutional directive requiring Parliament to adapt the presidential removal framework to the distinct constitutional position of the deputy president. However, the absence of such legislation does not vitiate the impeachment process already undertaken. We further hold that under Article 145, the Senate was at liberty to conduct the trial either by way of plenary or through special committee. The right to fair trial under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process, but does not undo the impeachment itself, given the finality of Article 145, sub-Article 7, and the constitutional absurdity that would arise from dual incumbency. The Constitution is the grundnorm, and where that grundnorm deliberately and unequivocally withholds authority from the court, such limitation must be respected.
I will deal with the aspect of remedies. Before pronouncing our final orders, we deem it necessary to first address the nature of remedies sought and to explain their constitutional foundation. This court has been invited to grant various reliefs arising from the partial success of the consolidated petitions. Our jurisdiction to issue such reliefs is firmly anchored in Article 23 of the Constitution, which empowers the court to grant appropriate remedies for the enforcement of rights and fundamental freedoms. These remedies include declarations of rights, injunctions, conservatory orders, declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 2, sub-Article 4. Orders of compensation and orders of judicial review. The courts have over time provided guidance on the considerations applicable in granting constitutional reliefs. In affirming that a court is not confined to the remedies expressly enumerated under Article 23, the Court of Appeal in Total Kenya Limited versus Kenya Revenue Authority 2013 reported, held that even where specific reliefs are expressly provided, a court is not precluded from issuing any other orders under the inherent jurisdiction, as long as such orders are necessary to ensure that justice is done between the parties. In the same vein, the High Court in Simeon, Kioko, Kitheka, and 18 others as County Government of Machakos and others, held that Article 23 of the Constitution does not expressly bar the court from granting conservatory orders where the constitutionality of legislation is challenged. Similarly, in Republic versus Ex parte, Judasama, the court emphasized that courts retains inherent jurisdiction to fashion appropriate remedies to secure the ends of justice. Speaking to the nature of appropriate reliefs, the Constitutional Court of South Africa in Force versus Minister of Safety and Security said as follows, and I quote, appropriate relief will in essence be relief that is required to protect and enforce the Constitution. Depending on the circumstances of each particular case, the relief may be a declaration of rights, an interdiction, an interdict, a mandamus, or such other relief as may be required to ensure that the rights enshrined in the Constitution are protected and enforced. It is, if it is necessary to do so, the courts may even have to fashion new remedies to secure the protection and enforcement of these all-important rights, end of quote. Regarding declarations and damages for constitutional violations, the Court of Appeal in Gitobo, Imanyara, and others versus Attorney General, report in 2016, emphasized that constitutional remedies are not confined to declarations alone, but may extend to compensatory relief where rights have been infringed. The court observed that damages serve not merely as recompense to injured party, but also as a means of vindicating the Constitution itself, and ensures that violations are met with effective and meaningful redress. In referring to Lord Nichols at paragraph 18 and 19 of that decision, the Court of Appeal affirmed the position that, and I quote, when exercising this constitutional jurisdiction, the court is concerned to uphold and vindicate the constitutional right which has been contravened. A declaration by the court will articulate the fact of the violation, but in many cases, more will be required than words. If the person wronged has suffered damage, the court may award compensation. The comparable common law measures of damages will often be a useful guide in assessing the amount of this compensation. But this measure is no more than a guide, because the award of compensation under Section 14 is discretionary, and moreover, the violation of the constitutional right will not always be conterminous with the cause of action at law. An award of compensation will go some distance towards vindicating the infringed constitutional right. However, how far it goes will depend on the circumstances, but in principle, it will not suffice. It may not suffice. In fact, that the right is violated was a constitutional right adds an extra dimension to the wrong. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, emphasize the public outrage, emphasize the importance of the constitutional right and the gravity of the breach, and to deter further breaches. End of quote. All these elements have a space in this additional in the additional award. Redress in Section 14. Sorry, that's still the quotation which I did not go through it. In this present case, and against this background, and having found that the rights of His Excellency Gachagua, were infringed, it is our considered position that declaratory relief and reasonable damages ought to be granted, not only to address the injuries suffered, but also to vindicate the Constitution and deter future violations. We now turn to examine the efficacy of the other reliefs. The petitioner sought an extensive range of remedies. In total, 49 declarations were prayed for, distributed across several thematic areas. 9 declarations relating to public participation, 15 declarations touching on the impeachment motion and process, 3 declarations on the fair hearing and due process, 3 declarations concerning the Senate proceedings and committee process, 2 declarations on standing orders, 1 declaration on the National Assembly and the gender representation, 8 declarations on the appointment of His Excellency Kindiki as Deputy President, 5 declarations on the vacancy in the office of the Deputy President and the nomination process, 2 declarations on violation of voters' rights, and 1 declaration regarding the members of the NIS. Beyond declaratory relief, the petitioner has also sought 5 orders in the nature of certiorari, 2 orders of mandamus, and 2 injunctive orders. They further prayed for a statement of His Excellency Gachagua to the office of Deputy President, an order for apology and cause. In addition, there was an elaborate prayer for damages and compensation. In considering the relief sought, it is evident that the two prayers have become moot. The first is the injunction that seeks to restrain the President, National Assembly, and any other state organ from proceeding with or effecting the appointment of any person to the office of the Deputy President pending the hearing and determination of the petitions. The second is the conservatory order restraining the respondents from collecting signatures, lodging any motion, or conducting any proceedings seeking to impeach the Deputy President. For clarity, these prayers are disallowed. Regarding the relief seeking the reinstatement of His Excellency Gachagua as the Deputy President of the Republic of Kenya, we do note that His Excellency Gachagua, through his pleadings and submission by his legal team, expressly abandoned the quest for reinstatement and indicated that he was no longer interested in pursuing it. Nevertheless, since other petitioners continue to press for the said relief, it remains necessary for this court to pronounce itself on the matter. Article 145, subarticle 7 of the Constitution provides as follows, I quote, if at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. This provision speaks to the finality of the Senate's resolution once it upholds an impeachment charge. Upon such resolution, the President or Deputy, as the case may be, stands impeached and ceases to hold office. The constitutional text is categorical that the cessation of office is automatic and does not require any further act of implementation. The impeachment resolution, once validly passed by the Senate, is self-executing and a fait accompli. The constitutional design is deliberate in this respect. It does not envisage an instance where the impeached president or deputy president may be reinstated within the framework of the presidency. The vacancy resulting from the impeachment resolution can only be filled through the procedure under Article 149, Subarticle 1. Even in the unlikely event that Parliament and the President wish to return the impeached office bearer, such a cause will still be subject to the availability of the vacancy and the nomination process prescribed by the Constitution. To hold otherwise presents profound constitutional and practical difficulties. The office of the Deputy President is not merely a matter of judicial declaration, but is intertwined with constitutional processes, political accountability, and the functioning of the executive. To order reinstatement in circumstances where the vacancy has already been filled would amount to the court usurping powers reserved to the people and their representatives under the Constitution. It would upset the delicate balance of separation of powers and create a constitutional absurdity. For the Constitution does not envisage two serving deputy presidents at any one time. The court cannot undo what the Constitution itself declares to be conclusive. Reinstatement, therefore, is not a viable or appropriate relief in the circumstances of this matter. Before leaving this subject, we find it necessary to acknowledge and comment on the doctrine of constitutional dilemma that arises in these proceedings from the tension between the constitutional finality of impeachment and the vindication of rights. This tension is highlighted by the comparative jurisprudence, most notably in the United States, where courts have adopted a principle of total avoidance, treating impeachment as non-justiciable. Yet our own constitutional framework demonstrates that avoidance cannot resolve the question that persists. In view of the recurring tension, a constitutional amendment clarifying the scope of impeachment finality and the role of judicial review may be warranted. At this juncture, we also find it necessary to distinguish the process of removal of a county governor from that of the president and the deputy president. To begin with, Article 181 of the Constitution sets out the grounds upon which the county governor may be removed from office. They are gross violation of the Constitution or any other law, B, serious reasons to believe that the governor has committed a crime under national or international law, C, abuse of office or gross misconduct, and D, physical or mental incapacity to perform the functions of the office. Article 181, Sub-Article 2, assigns Parliament the responsibility of enacting legislation to provide for the procedure for removal of a county governor. That legislation is the County Government Act, which we'll be referring to as the County Act in this discussion. And Section 33 thereof prescribes the detailed procedure. It provides for initiation of a motion in the County Assembly, transmission of the resolution to the Senate, investigation by a special committee, the governor's rights to be heard, and ultimately a vote by the Senate delegations. If upheld, the governor ceases to hold office. If rejected, the motion may only be reintroduced after 3 months. When this process is juxtaposed with the removal of a president and deputy president, and Article 144 and 145, several key differences emerge. First, whereas the president and the deputy president may be removed either on grounds of incapacity or impeachment, a county governor is removable only on the 4 grounds enumerated in Article 181. Section 33 of the County Act, however, introduces impeachment terminology, thereby expanding the constitutional parameters in a manner that is troubling. Second, the removal of the president and the deputy president is provided for directly in the Constitution, while the removal of a governor is legislated under the County Act. This distinction is critical. Under Article 2, Sub-Article 4, legislation is subordinate to the Constitution and may be declared unconstitutional by a court, whereas constitutional provisions themselves cannot be impugned. Thus, while the Senate vote under Articles 144 Sub-Article 10 and 145 Sub-Article 7 is final and beyond judicial review, the Senate vote under Section 33 Subsection 7 of the County Act is susceptible to challenge. Courts may proceed to stay and quash a resolution to remove a governor and even halt the filling in of the vacancy, but such judicial interventions cannot be imagined in the case of a president or the deputy president. Third, the manner of filling in the vacancies also differs. Under Article 149, a vacancy in the office of the deputy president is filled by presidential nomination and voting in the National Assembly, whose vote stands final and it is self-executing. By contrast, the Constitution does not prescribe how a vacancy in the office of deputy governor is filled. Section 32D of the County Act provides for nomination by the governor, approval by the County Assembly, and appointment thereafter. This statutory process, unlike the constitutional one, is amenable to judicial review and may be stayed or quashed. It is therefore on account of these glaring differences that this court cannot apply mutatis mutandis, the jurisprudence on removal of county governors to the removal of the president or deputy president. We nonetheless affirm that where binding judicial findings on governors' removal are squarely applicable to issues before us, we cannot run away from the same. This includes the pronouncement by the Supreme Court on the second case on the choice between plenary or special committee. In sum, therefore, whereas Article 144 and 145 embodies what may be termed as constitutional finality, the provisions of the County Act represent a form of statutory finality, thereby actuating the distinction between the two. We now turn to His Excellency Gachagua's quest for pension and emoluments under Retirement Benefits Act. The preamble of the Act makes clear that it is an act of Parliament to provide for granting of pension and other emoluments and retirement benefits to persons who hold the office of Deputy President and persons who have served as Prime Minister, Vice President, Speaker, Deputy Chief Justice, or Chief Justice after 1st of January 1993 and for connected purposes. Section 7 of the Act provides for the pension and other benefits of a retired deputy president or a retired vice president. Section 2 defines a retired president as a person who, having held the office of deputy president, has ceased to hold office as such in the manner specified in the Constitution. The interpretive question that arises is whether a deputy president who ceases to hold office by reason of impeachment can be deemed a retired deputy president within the meaning of the Act. Whether courts can legitimately interpret impeachment as retirement is a weighty and novel question. None of the parties address us on this issue. We are therefore of the considered position that it is not properly before us to pronounce ourselves on the same, for that will be presumptuous and will amount to stepping beyond the pleadings and the submissions of the parties. Accordingly, we decline to make any findings on this point. The parties are at liberty to pursue the matter further. An order of mandamus was sought to compel the National Assembly and the Senate to promulgate a constitutionally compliant procedure for removal of the deputy president by impeachment. We find this prayer to be merited. For clarity, the lack of such legislation per se does not, however, impugn the instant impeachment proceedings. Next, having found that the fair trial rights of His Excellency Gachagua were infringed when the Senate declined to allow the adjournment, that is in itself is a vindication of His Excellency Gachagua. We, however, hasten to add that the violation does not have the effect of quashing the Senate's resolution to impeach His Excellency Gachagua for precisely the same reasons we have provided with respect to the finality of the impeachment process. If the Senate's resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, Sub-Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, while the infringement of fair trial rights is acknowledged and vindicated, it does not undo the impeachment itself. The appropriate remedy lies in declaratory reliefs and damages to vindicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitobu Manyara's case, it is our position that the violation of His Excellency Gachagua's fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitobu case was resolved a decade ago with Mr. Gitobu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, A declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, for the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.
When Her Ladyship, the Justice Dr. Mugambi, was reading part of the judgment, if I heard correctly, she said that the 10th respondent, UDA, filed written submissions on 28th August 2026. If my hearing is correct, then quite manifestly that is a typo that the court might wish to correct. Secondly, the first petitioner applies to have a copy of the judgment, 1, and 2, typed copies of the proceedings, and 3, a complete set of the video recording of the proceedings. We would wish to have those as quickly as possible, of course, upon payment of the necessary court fees. It's a long judgment, and I am sure the first petitioner will want to be advised once we as counsel understand each of the issues addressed in the judgment. This honorable court has rendered its opinion, so there is nothing to be raised with this honorable court. But once we understand each issue by reading the judgment, the proceedings, and the video recording, we will then be in a position to advise the first petitioner, for example, on whether to pursue his other rights, as this court has indicated. I thank the court.
Thank you.
May it please you, my lords, my lady. Njeri Maina for the third petitioner. I wish to request for the typed certified proceedings, the certified judgment, and my lords, my lady, for the tidiness of the proceedings, I request on behalf of all other petitioners in this matter. The third petitioner has already filed their notice of appeal. We request that you expedite the proceedings and the judgment so that we can take it on from here. Thank you.
My Lord, my name is Devan Jiru. I have sat here for approximately 10 hours listening to this judgment. I certainly have heard you clearly and the disposition. Equally, despite it being the judgment of the court, I do not agree with some of the issues that the court has deliberated and the conclusion the court has arrived at. And most importantly, my Lord, when we came before you, we only did not just come for judicial recommendations on legislations. We thought that, my Lord, will leave this court with a clear judgment on how a violation ought to be dealt with. When we came before you, my Lord, and we moved you, most importantly, on the issues of constitutionality of the manner in which the proceedings were conducted, we did not come here for a remedy of a legislation. It will not benefit my clients whatsoever. And for that reason, my Lord, and granted the dissatisfaction with your judgment, I have equally advised my clients for the 4th to the 49 petitioners to launch and prefer an appeal. For that reason, my Lord, would wish to be supplied with certified copies of the proceedings, the judgment, and the transcript. And for the reason, my Lord, that we need the transcript is that, my Lord, part of what was delivered by Justice Murima when he was deliberating on the issue of the plenary and the committee, I can tell you, I had never heard what he said and what he concluded. I therefore, my Lord, would wish to have the transcript provided in verbatim, so that, my Lord, we're able to deliberate and internalize them. We are otherwise not dissatisfied. We are otherwise dissatisfied, and we shall not watch when the Constitution is being buried. Thank you.
Your Lordships, my lady, my name is Gachagua for the 10th to 41st petitioners. And my Lord, I would like to request for the same materials that Senior Counsel Paul Mwita has requested for. Thank you, my Lord.
My lords, my lady, I do associate myself with the submissions of fellow counsels. My Lord, there is a new twist into our constitutional declaration that you find a breach has been made, but then no outright remedy to that breach. My Lord, if the Constitution has been breached, then clearly it means then the Senate where I sat and I followed the proceedings, it means that it didn't do its duty as required by the Constitution. So we wish to appeal and we wish to be supplied as quickly as possible. We pay. My name is Daniel Manzo for third interested party. We will wish to be supplied with all the necessary proceedings certified so that we could advise our clients appropriately. I thank you, my Lord.
My lords and my lady, my name is Sakimpa. I do appear for the 4th to 8th petitioners. Your Lordship, we do confirm that we've already received instructions from our clients to appeal, and we have since filed our notice of appeal, and we request for the typed proceedings to be urgently provided. Thank you.
My Lord, I'm equally instructed by Kibe Mungai to make the same application. He has equally instructed me to inform the court that it's important that we don't preside over the funeral of our constitution.
My lords and my lady, I'm Phyllis Wangui Kamau, appearing for the 43rd petitioner, and I wish to associate myself with the submissions of Senator Manzo because the decision finds us in a constitutional absurdity. And for that reason, we do wish to appeal, and I join my sister, Honorable Njeri, and Senior Counsel Muite to request for the type proceedings and the judgment. Thank you, my lords and my lady.
If it may please you, my lords and my lady, I'm Omanyi for the 57th petitioner. I think there was also a mistake with regards to the 57th petitioner. As the court was reading the judgment, it said that we had not filed our submissions and did not appear during the hearing, yet we appeared. So I think that is a mistake that in the judgment and the court can correct the same. We also intend to file an appeal against this decision, and we request a copy of the judgment and proceedings, certified copies of the proceedings. Much obliged.
My Lord, my lady, I find myself in a very inauspicious position. I commenced the proceedings, I closed. But my Lord, the reason is...
Excuse me, please respect the rights of the parties before the court. You are not before the court. Please sit down. Let's finish this matter or this file. If you have an issue with another file, we'll allow you to talk.
Okay, very well.
On behalf of the respondents, I presume we have no objection to the request for proceedings, and we have no request. We are waiting, my lord, for the appropriate time to respond to the appeals, and so we will wait for them in the Court of Appeal. We are happy to do that. Thank you. Finally, my lords, we just want to thank the court for delivering judgment. I think we've sat here for 9 hours from 12 to now. So we thank you for that, your patience. Thank you.
Mr. Kenyanjui.
Thank you very much, Your Lordship. My Lord and my lady, I think I prefer them instead of bending.
Are you addressing us on this file or on another file?
This file.
This file, you are not a party.
It's because, my Lord, I addressed you.
We cannot mix issues.
Yes, we're not mixing. Because in this file, it is implicated in civil application E291. All these petitions are part of E291. So the proceedings that commence these proceedings are relevant to my client. That's why, my Lord, I was making a similar application when I addressed the court. If I could get an audio transcript, if I cannot get the type, that's okay. I can get an audio. That is necessary for me before the Court of Appeal, so that I can show the Court of Appeal I brought to your lordships and my lady dependency of civil application E291 of 2026. That was limited to only that. Beyond that, I don't want to vex you. It's been a long day. So my request is for the transcript of the commencement of the proceedings up to the point that your lordship then directed that I shouldn't address you any further, because it implicates civil application E291 of 2026. I'm much obliged. Thank you.
So we can avail them within 5 days. Huh? 5 days. Thank you very much. The prayers for certified proceedings, certified judgment, copy of judgment, and certified transcripts has been allowed, and you will be given those documents in the shortest time possible. We don't have a problem because all those documents are actually ready. So you should be able to get them within 3 days from now. Thank you very much. I think we can adjourn.
Good night.
Good night.